Greetings, my name is Deanna Hasler. I am doing the oral report for the number 20, the case for and against allowing cameras in the courtroom, for the EIU class, Freedom of Expression. My research went to the very beginnings of cameras in the courtrooms when we first started seeing cases brought up before the Supreme Court in arguments because of the effect of a camera in the courtroom. In Paul Hightower's article, Canon 35 Remains Despite Courtroom Tests, he explains about Estes versus Texas, about the murder trial, and how the Supreme Court in 37 overturned the conviction because they felt the pre-trial coverage with the cameras affected the jury pool and may have tainted the proceedings. After that, the American Bar Association went ahead with Canon 35, which stated that no cameras or radio information would be allowed in the courtrooms themselves. Now, the trick to this is canons were voluntary that the justices and the lawyers were supposed to uphold. States' rights always take precedence. So Florida and Texas and a few others jumped even after the cooling off because of Estes being overturned until 1965, when Florida had a case come before the Supreme Court, which was Chandler v. Florida. Now, in most all the articles that you read to date, they still go back and state Chandler was the case that allowed cameras to be in courtroom and made it official and very comfortable for them to have cameras and videos in the courtroom. When the 35 article came through, what you have to understand is that cameras were much different than they were today. Cameras in 1935 were bulky, they needed extra lighting, they needed room, they needed people to stand still. So not only would it be disruptive to the proceedings as people being comfortable around cameras, it also came down to they were just noisy and bulky and disruptive. But in the 60s, when Chandler came through, it was about a police burglary, or policemen that committed a burglary and were convicted. And they took it to the Supreme Court saying because of the, because there were cameras in the courtroom, they did not receive a fair trial. The Supreme Court ruled in favor of the conviction. And Chief Justice Warren Burger said though he wouldn't have cameras in his courtroom, this was a states' right issue rather than so much about the cameras. The cameras really didn't have as much to do with it as being a states' rights. And that was not the job of the Supreme Court to change state rules. In the 70s and the 80s, it bloomed for cameras in the courtroom. They went to many states, though it was almost in the 2000s before the final states allowed cameras in the courtroom. And Florida was very good about having a set of rules about cameras in the courtroom, and Justice Sandberg had come up with the 6 parts that challenged why and how you had cameras in the courtroom. One was you couldn't have any physical disturbance or disruption, as we talked about with the older cameras. No adverse psychological effect on the participants. The exploitation of the courts for commercial purposes. Prejudicial publicity. The effect of particular categories of witnesses. And the infringement of privacy rights on participants. And this was from the Stephen Craig article in 1979, Cameras in the Courtroom in Florida. Because they went ahead and kept working on a really sufficient set of rules, the American Bar Association started relaxing a little bit of their information too and their dislike of it. But in the law poll, Cameras in the Courtroom, from the American Bar Association Journal, they did a 1979 and 1982 survey of their members in states that had cameras in the courtroom and in states that were negative to cameras in the courtroom. And they found there still was a preponderance of members who were opposed to cameras, even in the states where they were being used. The 1982 survey was better than 1975 in the numbers, but a special note was on the table 5 in that article. They had a 93% agreement with if a judge felt at any time that the camera was affecting the courtroom, they could go ahead and stop it. Many of the lawyers that were favorable to the camera still felt there were challenges of distractions and sensationalism. They were worried about grandstanding to the cameras rather than working their job in the court. And one of the greatest changes is having cameras in the courtroom, and it was seen as a positive to many people, especially in Florida, because it was a way to allow everyone to be in the court. And one of the founding issues of our Constitution was that we would have a fair trial in open court by a jury of our peers. Well, how much more can it be open than have it video streaming to any place in the world through court TV? That's one thing. The one thing that everybody worries about, and one of the negatives to having cameras in the courtroom, is how the information is used. But that's the same with any type of media. The problem is, when they say a picture is 1,000 words, what is a video worth? Chief Justice Warrenberger, who went through many of these trials and many reviews by the Supreme Court, stated the prejudice of television may be so subtle that it escapes from ordinary methods of proof, but would gradually erode our fundamental conception of a trial. And this was brought to us by Stephen Craig and his article. But even Warrenberger changed his tune, and that was right after Estes. And after he had gotten done with the Chandler trial, like I said, even though he didn't want it in his court, and both federal and Supreme Courts do not allow cameras in the courtrooms, he went on to say that he had found no proof that the cameras had affected many of the trials. In 2009, John White, for the Florida Bar Journal, wrote an article, 30 Years Since Chandler. And in it he stated, because of Bush v. Gore, and allowing the whole world to watch as court worked going through that situation, cameras in the courtroom were too important not to have. It made our system seem open and honest to those around. But at the same time, Mrs. Chance wrote an article, Sandra Chance that is, where she stated that the cameras aren't the problem. The problem is how the system works. And you can't take the cameras away to change that system. You need to fix the system itself. The biggest challenge in the law poll and in all the articles that I found that were against it was they weren't sure how cameras affected not only the trial but the participants long-term and short-term. There had been surveys, but how can you have a very good experiment or research done that is above board and takes into account only the variables you needed? One was attempted in the University of Minnesota. The psychology researchers had a simulated courtroom and used students that got college credit as both the witnesses and the jurors. And they found that though they were more stressed giving testimony in front of the camera, they actually recalled more details without prompting. This works for kids that are getting a college grade, but how does it affect people that are fighting for their lives in a murder trial? So you get both the pros and the cons. You've got the one side who feels that cameras are disruptive and will cause problems, and you have the other side saying technology is a great thing. It's no different having cameras in the courtroom than it is to have print media in the courtroom. the negative looks at the O.J. Simpson trial as the reason why it doesn't work. At the same time, the positive look at the O.J. Simpson trial and says that showed us what we need to fix in our system, not the cameras. The camera, like a gun, is simply a tool. It's how you use it that makes a difference. And in conclusion, I'd like to tell you about a symposium that the Brigham Young University Law Review discussed. And their comments were that you had both sides, the media and the courts, that felt the other didn't really respect their jobs. And part of the challenges with ever allowing cameras in federal courts or Supreme Court revolved around making sure it wasn't going to be sensationalized. For the ones that believe cameras are good, you need only look at convictions that can be upheld because there's cameras in the courtroom, and how it opens up the world for the rest of us to see what's going on. At the same time, you look at, if the glove doesn't fit, you must acquit. Words that became a lexicon in our culture because of cameras in the courtroom. I hope this gave you some information on the pros and cons, or the for and against cameras in the courtroom. And I hope you do your own research. It was very interesting to learn about this and learn how it came about. And I was very against them when I first started this, and came to the conclusion that it's not the cameras, it's how they're used. Have a great night.